In January of 1458, in the small Burgundian village of Savigny, a judge took his seat. A prosecutor rose to speak, and 9 witnesses were called by name to testify in a murder case. The victim was a 5-year-old boy named Jehan Martin. The accused stood in custody, held in the local jail for weeks at the same daily rate charged for a human prisoner. The accused was a sow. Beside her, also under arrest, were her 6 piglets. This was not a joke, it was not satire, and it was not theater. It was a formal legal proceeding, recorded by a clerk, argued by lawyers, and decided according to the customary law of Burgundy. And it was not unique. Across late medieval and early modern Europe, especially in the lands that are now France, Switzerland, Germany, and northern Italy, courts summoned, tried, sentenced, and sometimes executed animals. Scholars have documented roughly 200 such proceedings, and pigs appear in more of them than any other creature. The easy explanation is the one we reach for first. These people were ignorant. They were superstitious. They did not understand the difference between a criminal and a farm animal. But the surviving records point somewhere stranger and more interesting. The courts followed procedure. They weighed evidence. They distinguished between defendants. The trials were not a failure of reason. They were an attempt to use reason, law, and ritual against something that terrified every community in Europe, harm that arrived without warning and without anyone to blame. To understand why a pig could stand trial, you first have to understand how close animals and people actually lived. A late medieval village was not divided into human space and animal space. Pigs moved through the streets on their own, rooting through refuse, wandering in and out of open doorways. They were not the pink, placid animals of a modern farm. They were lean, bristled, closer to wild boar, heavy enough to knock down an adult, and more than capable of killing a small child left near a doorway or a cradle. Livestock slept under the same roofs as their owners, or in pens against the house wall. A family's pig was its savings account, its winter food, and its walking insurance policy. Children and animals shared the same mud, the same lanes, the same unfenced yards. In that world, the line between household and herd, between neighbor and animal, was thinner than anything we know. And when that closeness turned deadly, when a sow attacked a child in a lane that everyone used every day, the community faced a problem that went beyond grief. Something familiar had become monstrous, and it had happened in public, inside the ordered world of the village. The legal response took 2 very different forms, and the distinction matters. When an individual domestic animal, usually a pig, sometimes a horse, a bull, or a dog, injured or killed a person, the case generally went before a secular court. These proceedings could look remarkably like an ordinary criminal prosecution. The animal was seized and detained. Formal charges were drawn up, often in precise legal language. Witnesses testified. Lawyers argued. A judge, sometimes after consulting experts in local customary law, delivered a verdict. Conviction usually meant death, and the preferred method was hanging, carried out publicly by the same executioner who hanged human criminals, and paid for his work at the same rates. The second form belonged to the church. Ecclesiastical courts did not usually deal with a single guilty pig. They dealt with multitudes: rats, mice, locusts, caterpillars, weevils, creatures that could not be caught, jailed, or hanged, but that could destroy a harvest and push an entire community toward hunger. These proceedings involved formal summons read aloud, appointed legal representatives for the accused, and arguments about jurisdiction and divine order. When the animals failed to comply, the court's ultimate weapons were spiritual: solemn curses, anathema, and in some accounts, the threat of excommunication, commanding the creatures to leave the fields within a set number of days. It is tempting to laugh, and people at the time were not blind to the strangeness either. But consider what a plague of weevils meant in a subsistence economy. A ruined vineyard or a devoured barley crop was not an inconvenience. It could mean a winter of hunger, debts that swallowed a family's land, children who did not survive to spring. Against that kind of disaster, a peasant community had almost no practical tools. What the church offered was a framework, a way to stand in front of the catastrophe, name it, formally demand its end, and place it inside a universe that was still governed by law and by God. The best documented of these cases, such as the trial of the weevils of Saint-Julien in the French Alps in 1587, dragged on for months. The insect's appointed lawyer argued from the book of Genesis that God himself had given the creatures the right to eat the plants of the earth. Which brings us back to Savigny, because the details of that case are exactly what make the easy explanation collapse. The formal defendant in the paperwork was actually a man, Jehan Martin, the owner of the pigs. But from the beginning of the proceedings, he was accused only of negligence, of failing to keep watch over his animals, and he faced no punishment for the killing itself. The court's real attention fell on the sow. Witnesses established what she had done. The judge consulted the customs of Burgundy. She was convicted and sentenced to be hanged by her hind legs from a tree. And then the court did something a mob would never do. It looked at the 6 piglets, which had been found beside the body, stained with blood, and it acquitted them. The reasoning survives in later accounts of the record. They were young, they had been led astray by the bad example of their mother, and there was no direct proof that they had taken part in the attack. Insufficient evidence. A distinction between principal and bystander. Whatever this was, it was not blind revenge. A community consumed by rage does not spare the piglets on a technicality. The court was performing law, carefully, at real expense, over animals. Why? Even at the time, the practice sat uneasily within European legal thought. The Roman legal tradition, which educated jurists knew well, held that an animal lacks reason. Without reason, there can be no criminal intent. And without intent, there is no crime. Under that logic, responsibility belongs to the owner, not the beast. Thomas Aquinas had argued in a similar direction on the religious side. Animals are instruments of God's creation, and solemnly cursing them is either pointless or blasphemous. Medieval and early modern law was not one system, but a layered argument between Roman principles, church doctrine, and stubborn local custom. The animal trials lived in the tension between them. In the 16th century, the celebrated French jurist Barthélemy de Chasseneux, whose name later became attached to a famous and possibly embellished story about defending the rats of Autun, wrote an entire legal treatise defending the propriety of such proceedings, provided the correct procedure was followed. The procedure, for these men, was the whole point. Historians today do not agree on a single motive, and the honest answer is that there probably was no single motive. Some scholars see the trials as a ritual for restoring order after a frightening, apparently random tragedy, converting private horror into public process. Some see courts and churches asserting jurisdiction, demonstrating that their authority reached over everything within the community, human or not. Some read the trials as a defense of hierarchy itself, a declaration that when an animal killed a human being, the proper order of creation had been violated and had to be visibly repaired. Others suggest a more practical message aimed at owners. Control your animals, because the community will act if you do not. Each interpretation explains some cases and strains against others. What they share is this: the trials made sense to the people who held them, inside a world where law, religion, nature, and survival were not separate categories. The practice faded slowly. There was no decree that ended it, no single moment of enlightenment. Through the 17th and 18th centuries, as legal thought increasingly centered criminal responsibility on the reasoning human mind, prosecuting a pig came to seem not wicked, but incoherent. The cases thinned out, with scattered examples lingering surprisingly late. The animals left the courtroom not because people stopped fearing them, but because the definition of a criminal had changed. And that is the part of this story that does not stay safely in the past. Modern law no longer reads charges to a sow. But when an animal kills a person today, it is still, in most places, destroyed, through an administrative order rather than a verdict. When a species threatens crops or livestock, it is culled. When disaster strikes, the first public demand is still to identify who or what is responsible, and institutions still exist largely to answer that demand. The villagers of Savigny hanged a pig because unexplained suffering was unbearable, and a trial made it bearable. The forms have changed. It is worth asking whether the need has. So tell me what you think. The animals are no longer brought before the judge, but when something beyond human control causes suffering, have we really stopped searching for something to blame? Leave your answer in the comments. I read them. And if this kind of history is what you came here for, like the video and subscribe, because there are many more strange chapters of the past waiting to be reopened.